In 1991, three republics of former Soviet Union, Armenia, Georgia, and Azerbaijan, held independence referendums in order to determine whether the voters were in favor of leaving Soviet Union or not. Based on the results of these referendums, Armenia, Georgia, and Azerbaijan officially became independent. The newly established states faced with several new challenges. First of all, they were looking for a democratic society with democratic institutions, with independent judiciary, with active participation of civil society in decision-making process. But at the same time, they were faced with regional conflicts, with inherited legislation and institutions of former Soviet Union. The constitutions of the mentioned states, they were adopted in a short period of time, but the rest of the legislation remained the same. I can bring just one example. Criminal codes of Azerbaijan and Georgia, they were adopted only in 1999. Criminal code of Armenia, it was adopted and entered force even later, only in 2003. Before that, the former criminal code, the Soviet criminal code, was in force, providing death penalty, though it was put in moratorium, and also providing criminal responsibility for voluntary sexual intercourse between the adults of the same sex. Of course, later on, the majority of the legislation was improved, but even now, not all the legislation is updated in the states. The situation was even worse with the institutions. So the countries inherited Soviet institutions, and especially law enforcement, police and prosecution service, and also the jails. And these institutions continued to work in the same way as during the Soviet times. Torture, ill treatment, excessive use of violence, frequent detention were rather common. And of course, when talking about such kind of situation, one of the main reasons was the lack of knowledge in the field of human rights and in the field of international standards in this area. That's why one of the first steps taken by the states was implementing the requirements of international regulations. They tried to become parties to international treaties, conventions, covenants, agreements. So just some of the international documents which were signed or ratified by the newly established states were European Convention on the Protection of Human Rights, Covenant on Civil and Political Rights, International Covenant on Social, Economical, and Cultural Rights. Also, when talking about the Convention on the Rights of the Child, about the Convention on the Prevention of Torture and Inhuman or Degrading Treatment or Punishment, Convention on the Elimination of all forms of racial discrimination, Convention on the Elimination of all forms of discrimination against women, etc. In spite of the new regulations aimed to a better standard of human rights protection, their practical implementation is yet lacking. Important steps were taken in order to create specialized institutions on human rights protection. In the 90s, specialized commission on the issues of human rights were created on governmental level. Later on, the Institute of Ombudsman was created. Legally, it started functioning in Georgia since 1997, in Azerbaijan since 2002, and in Armenia since 2003. The main functions and powers which these institutions have include supervising the state of human rights protection over their jurisdiction and identifying the possible infringements of human rights and contributing to restoring the violated human rights and freedoms. However, the institutional framework is yet in need of reforms. In this aspect, the decisions of European Court of Human Rights are important and became ground for making reforms in our institutional framework as well as in legislation. For instance, European Court of Human Rights has addressed Armenia, Georgia, and Azerbaijan in regard to the infringement of Article 2, right to life. We dealt with European Court in regard to issues with the lack of positive obligation of the state in regard to protection of right to life, as well as dealing with domestic violence issues and extensive use of violence by law enforcement bodies. We dealt with the infringements in regard to Article 3, prohibition of torture, and in this case Armenia, Azerbaijan, and Georgia were addressed as well, equally I can say, and especially in cases when they dealt with the people deprived of liberty. Violations of Article 5 were detected actually when dealing with keeping of patients and treating patients in specialized institutions, psychiatric institutions, against their will, and also when dealing with detaining the people, extensive use of detention. And also we had cases with violation of Article 6 in regard to fair trial, and actually European Court of Human Rights addressed the countries in regard to the tenure of the hearings and also the effectiveness and the result. In regard to effectiveness. Based on the decisions, health changes were taken by the countries. For instance, it brought to the reduction of detained population in the prisons in Armenia and in Georgia. But at the same time, there are other obstacles as well. For instance, low salaries, a weak social economical situation of the majority of the society members create obstacles for imposing fines instead of sentencing, and this should be taken into consideration when dealing with the possible reasons for human rights violations. Another sweep of reconsidering the level of human rights protection in the countries of South Caucasus were Rose and Velvet revolutions, which took place in Georgia and Armenia. Actually, the societies tried to get rid of violations which took place in election process, get rid of corrupt officials, and establish a real democratic society. And that's why the societies moved towards new government and new strategies. For example, in Armenia, a new strategy for the protection of human rights for 2020-2022 was adopted in 2019. Again, it was addressing the establishment of European values in the protection of human rights, and here EU-Armenia comprehensive and an enhanced partnership agreement as well as EU-Armenia human rights dialogue platform became a vital points for the implementation of the strategy. First of all, when coming to the agreement, one of the goals of the agreement was expanding cooperation in the field of freedom, security, and justice. And while talking about the platform, it became a good tool for assessing the progress made by the state when dealing with the protection of human rights. And as implementation of the Act's recommendations and suggestions of international of bodies which are established under international agreements are mandatory for the country, thus the decisions of European Court of Human Rights as well as recommendations of Council of Europe, UN agencies, and also European Committee for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment Committee on the Rights of the Child are of great importance as well. The strategy identified the main areas where the violations take place, and here we are talking about lack of tolerance and hate speech, about the violations in the field of freedom of assembly, about extensive use of violence by law enforcement, about discrimination and violence towards LGBT population. Special attention should be paid to four main points which I would like to address in South Caucasus. So first issue is in regard to the domestic violence issue, which is rather widespread in the countries of South Caucasus, especially in Armenia. For example, in Armenia, only a couple of years ago, a special law on the prevention of domestic violence was adopted. However, even now, the mechanisms on their implementation are not in place, and we have many cases on domestic violence issue. When dealing with the reasons of such a situation, probably the reason is the concept of traditional family with emphasized men's role and authority, which is really very strong, and rather frequently this role is misunderstood, and the men think that they have the right and possibility to punish the family members, including the women, even with the use of force. And probably this is also the reason for the situation when we have the selective abortions in Armenia, where the boy babies are more welcome than girls. The second issue is again concerned to the traditional societies existing in South Caucasus, and especially when dealing to the intolerance towards LGBT population. Harassment, violence, discrimination in regards to these people are rather common in South Caucasus. The third issue to be addressed is the problem of freedom of expression. Many international organizations have highlighted the problem of suppressing the mass media in Azerbaijan, and there are violations also in Armenia and Georgia when dealing with the freedom of expression. However, it's more transforming to the hate speech and intolerance, especially in social media, and also inciting hate speech. The fourth issue to be addressed in the country is the violation of freedom of assemblies, and it was determined in all three states of South Caucasus. And at the same time, the lack of state resources in ensuring the rights and freedoms of the population, especially when dealing with social rights, is also an important point. Especially here we deal with the violations in regard the right to health and labor. In general, we can conclude that post-Soviet background yet creates problems for the countries of South Caucasus when dealing with the protection of human rights.